Hi, everybody. Thank you for tuning into another episode of HSC TV. My name is Ryan Sanada, and I'm the Director of Legal and Government Affairs for the Hawaii Employers Council. We are a nonprofit trade association that provides HR and labor relations support to Hawaii's businesses. In this video, I will be giving you all an update on two new employment laws that came out of the 2017 Hawaii State Legislative Session. The first new law I'll discuss created broader leave rights for employees under the Hawaii Family Leave Law, or HFLL, which can be found at Chapter 398 of the Hawaii Revised Statutes. The second law that I'll be covering gave employees additional rights when going to an independent medical examination, or IME, in workers' compensation cases. This new law impacts Section 386-79 of the Hawaii Revised Statutes. Both new laws that I'll be discussing in this video have taken effect in July of this year. The HFL applies to companies with 100 or more employees and employees who have worked at least 6 consecutive months. Covered employees can take up to 4 weeks of leave each year upon 1, the birth or adoption of a child, and 2, to care for a family member with a serious health condition. Before this year's legislative session, covered family members included children, spouses, and parents. Under Act 128, which took effect on July 10, 2017, employees can now take leave to care for a sibling who has a serious health condition. This new law seems pretty straightforward, but a new question arises. Who is a covered sibling? In Act 128, the legislature did not define the term sibling, and the DLIR has not issued any guidance on the issue. Interestingly enough, the Hawaii Revised Statutes has definitions for children, spouses, and parents. Specifically for children, spouses, and parents, HRS 398-1 includes biological, adoptive, foster, and step family members. Therefore, it is likely that biological, adoptive, foster, and step siblings would also be covered. With regards to in-laws, however, the answer is unclear. Specifically, the HFLL covers parents and grandparents-in-law, but not a son or daughter-in-law. Therefore, we'll have to wait and see what the DLIR says about siblings-in-law. In any event, the DLIR has indicated that it will be issuing guidance on this issue sometime in the future. Such guidance will probably either be in the form of an FAQ or possibly updated administrative rules. Hopefully, the guidance gives us some clarification on what constitutes a sibling for purposes of the HFLL. In the meantime, employers are advised to allow employees to take leave for biological, adoptive, foster, and step siblings, and possibly even siblings-in-law. The second new law I will discuss, Act 172, took effect on July 11, 2017, and made 2 changes to claimants' rights when going to a workers' compensation IME that is ordered by the DLIR. Previously, under statute, claimants could bring a physician or surgeon to an IME. Under Act 172, claimants can now bring a chaperone to the IME, which, based on the plain definition of the word, could really include just about anybody. For instance, a chaperone could be an attorney, union representative, friend, coworker, or even a bodyguard. So what is the practical impact of this new law? Well, first, some physicians will not want to do an IME if there are going to be chaperones involved, and the physicians do not feel comfortable having a chaperone such as an attorney or union rep present during the examination. This could be a problem because there is already a shortage of IME physicians in Hawaii for certain medical fields. Second, if an IME physician cancels the examination because the claimant wants to bring a chaperone, it could result in a situation where the IME does not get rescheduled in time for a hearing before the DCD, or Disability Compensation Division. This would mean that the employer would not have an IME report to respond or refute the report of the claimant's treating physician. That could be a problem for employers in situations where they don't agree with the recommendations of the treating physician. The second component of this new law allows workers' comp claimants to record the IME upon consent of the examining physician. For example, the employee record the IME with a smartphone, such as an iPhone, or with a tape recorder or other recording device. The way I see it, this right to record the IME could play out in one of 2 ways. Number 1, the physician will object to the recording. The second possibility, however, is that some physicians might actually agree to the recording in order to ensure that there is no dispute as to what happened during the IME. On that note, I should clarify that this new law only applies to IMEs that are ordered by the DLIR. In other words, when the claimant and employer or carrier agree to the IME, the employee will not have the right to bring a chaperone or record the examination. This means that many claimants will likely now object to an IME requested by an employer and will require the DLIR to order the IME. So that way the claimants will have the right to bring a chaperone to the examination and possibly even record the IME. On a final note, this new law has a 2-year sunset provision, meaning that it is in a trial period for the next 2 years. If the law works out as intended, it could become permanent. If it proves to be problematic, there is a chance it could be repealed. If you have any questions about these or other laws from this year's legislative session, you can visit our website at www.hecouncil.org or email me at rsanada@hecouncil.org. Otherwise, that concludes our video. As always, it's been a pleasure speaking to you all. Until next time, thank you for tuning in to HEC TV. Have a great day.